The First Amendment to the Constitution of the United States says, Congress shall make no law abridging the freedom of speech. Because of our Constitution, with its Bill of Rights, we in the United States have a great deal of freedom in what we write, read, and say. But are there limits to this freedom? Is it necessary to balance an individual's freedom of speech against the well-being of the community? A speaker may express ideas that are so unpopular that the peace of the community is destroyed. Yet if a speaker is limited to expressing only popular ideas, there is no real freedom of speech. Can a person ever be punished if his speech threatens law and order in the community?
Of the birth of one of the greatest men of the 20th century, perhaps the greatest man of all time. Today is the anniversary of the birth of Adolf Hitler. Without Hitler, the red tide of Bolshevism would have swept away our country. Without Hitler, the race that has colonized and civilized the world, the race that has given culture and honor and purity to mankind, would have been mongrelized and lost forever. The spirit of Hitler is not dead, although our beloved Führer is physically gone.
My whole
his spirit,
was
his dreams,
because of these beasts.
his ideals live on. Thousands of us wait the day when we can rise up and cleanse the earth of the scum who pollute it. We will complete his sacred work. Here in America, we will complete it.
Nazi!
Get out of here!
Many lies have been told about Hitler and about Nazism.
Get out of here!
Let me tell you the truth.
People like you killed.
He weeded out the sick, the lame, the retarded. He eliminated those with tainted blood. Why? Not because he was cruel, but because he had a dream. A dream of a perfect, pure human race.
People like you should be in jail. They should put you in jail.
What do you have to come into our neighborhood for?
When you have a tumor, what do you do with it? You cut it out with a knife. Adolf Hitler was the knife that cut out the tumor of Judaism. Only Adolf Hitler had the courage to oppose the Jewish plot that was corrupting the world. Only Hitler had the imagination to conceive the final solution to the Jewish problem and the strength to apply that solution. It is history's greatest tragedy that he was struck down before he was able to exterminate every Jew in the world. Heil Hitler! Heil Hitler!
Douglas Newlin, you've been convicted of violating Section 415 of the Penal Code, disturbing the peace. There being no legal reason why judgment should not be pronounced, I've decided to sentence the defendant to the maximum punishment, 90 days in the county jail and a $200 fine.
This man has just been convicted of disturbing the peace. He feels his constitutional right to free speech was violated and will appeal his case to a higher court.
Please rise.
Department 7A of the Court of Appeals is now in session. The Honorable Ann Laramie, Mallory Hobby, James E. Ward, judges presiding.
You may be seated.
In a court of appeals, there is usually more than one judge. It is the judge's job to decide whether Douglas Newlin's conviction should stand or whether it should be set aside.
Case number 2263, People versus Douglas Newlin. For the sake of the defendant, I will say that this appeal is not a retrial of his case. Instead, our concern will be whether his conviction was in fact an interference with his constitutional right to free speech. Is counsel for Mr. Newlin ready to proceed?
Yes, I am, Your Honor.
You may proceed now.
Your Honors, my client Douglas Newlin has been sentenced to jail for disturbing the peace. It is our contention that this conviction violates his rights under the Constitution of the United States, which guarantees him freedom of speech. Let me make it clear that I do not share my client's views. What I am defending is my client's right to state these views. It is not Adolf Hitler, nor neo-Nazism that is on trial here today, but freedom of speech in a free society. And if we are to have freedom of speech, then we must be willing to grant that right, not only to speakers whose ideas we applaud, but also to speakers whose views we detest. Why is freedom of speech so essential to a free society? Perhaps Daniel Webster put it best when he said that if he were deprived of all his rights, save one, he would preserve the freedom to speak, for by proclaiming it, he would regain all the others he had lost. Or as Justice Oliver Wendell Holmes said more than half a century ago in Abrams versus the United States, the theory of our Constitution rests on a free trade in ideas, even the most unacceptable ideas. The state will argue, as it did in the lower court, that my client's speech did interfere with the lawful purposes of the country because it was followed by violence. But consider, my client did not incite, urge, or even suggest that his audience engage in violence. Instead, Mr. Newlin's speech was so obnoxious to his audience that they became a hostile crowd attempting to inflict violence on him. If the speech was dangerous, it was because the audience chose to violate the law in order to silence him. If Douglas Newlin had delivered a popular speech followed by tumultuous applause, he would not have needed a constitution to guarantee him his right to speak. In the late 1970s in Skokie, Illinois, Nazis wanted to hold a parade. The city feared violence because it had a large Jewish population, many of them survivors of Nazi death camps. The lower federal court decided that the city could not prevent the Nazis from marching and airing their views, even though they might be met with violence. The principle of freedom of expression required the city to protect speech, not silence it. In the earlier case of Terminiello versus Chicago, another exponent of fascism reviled Jews while outside a howling mob gathered, trying to prevent him from speaking. The trial court told the jury it could convict the speaker if the purpose of his speech was to invite dispute, encourage anger, and evoke a hostile reaction. The Supreme Court of the United States upset that conviction, saying that it is often the purpose of free speech to invite dispute and even anger. As Mr. Justice Douglas said in his opinion for the court, before speech can be punished, there must be shown a clear and present danger of a serious, substantive evil that rises far above public inconvenience, annoyance, or unrest. We would not permit the silencing of a patriotic orator because his audience reacts as this one did. And that is the heart of this case. It tests our commitment to freedom by asking whether we are willing to grant the same rights to one whose pronouncements are not only unpopular, but even despicable to us. I am confident, Your Honors, that in the long run, the strongest weapon we have against the kind of tyrant whose birthday the defendant commemorated is freedom of speech. As long as the channels of discussion are open, as long as odious notions may be freely spoken and freely challenged, as long as the human mind is free to inquire and the human tongue free to speak, we need not fear the tyrant, the demagogue, or the unpopular idea.
Thank you. Counsel for the state, you may proceed now.
Your Honors, this court must decide what is meant by freedom of speech. It is suggested that what is meant is absolute freedom. We merely ask, did the defendant only speak? And if the answer is yes, then he is constitutionally protected. If this is the test, and if the matter is this simple, then his case can be instantly decided, and the defendant can be released with our apologies, because, Your Honors, all he did was speak. I wonder, however, if the matter is that simple. Does the Constitution say that one may walk up to a black person and with immunity hurl vile racial insults in his face? Does the Constitution contend that one may leap to one's feet in a house of worship and drown out the service by shouting an anti-religious diatribe? And what about the person who yells fire in a crowded theater? Or the sadist who telephones a mother and falsely tells her that her child lies mangled and bleeding in the street? Only words, does the Constitution say? Surely, Your Honors, the Constitution does not, as it could not permit such license. Free speech must be balanced against society's need for security. I suggest that what the Constitution means by freedom of speech is not the absolute right to say anything at any time, regardless of the consequences. Some guidance may be found in the case of Feiner versus New York. Feiner stood on his soapbox and urged, as part of his harangue, that blacks take up arms to gain their rights. He antagonized the crowd, refused to stop speaking when requested by an officer, and he too was convicted of disturbing the peace, though no violence had yet erupted. The Supreme Court, in affirming Feiner's conviction, said, "The offense known as breach of the peace embraces a great variety of conduct destroying or menacing public order and tranquility. It includes not only violent acts, but acts and words likely to produce violence in others. When clear and present danger of riot and disorder appears, the power of the state to prevent and punish is obvious." Your Honors, I suggest that what the Constitution means by freedom of speech depends upon a consideration of many factors, such as the time and the place of the speech, the gravity of the danger that might result from the speech, and the immediacy of that danger, and yes, the intentions of the speaker and the availability of reasonable alternatives. I suggest we consider such factors in evaluating this defendant's speech. We might consider that he could have spoken anywhere, but he chose to ignore ordinary streets and bypass ordinary forums because he hunted for the jugular and found not just a Jewish neighborhood, but a synagogue to hiss his venom. He flaunted the symbol most calculated to open old wounds and cause fresh pain, the swastika. He spoke of weeding out the sick and lame as though people were plants. He spoke of cutting out tumors as though people were a kind of malignant growth. This to an audience whose nostrils still burned from the stench of Auschwitz and Dachau. In the 1942 Supreme Court decision of Chaplinsky versus New Hampshire, the court recognized that the Constitution permitted the punishment of fighting words. Words which by their very utterance cause a breach of the peace. Your Honors, this was not like the Skokie case in which violence was only a possibility. In this case, the audience was lashed by words which could not help but incite extreme reactions. This was not a hostile audience case at all. Instead, this audience was the victim of a sadistic speaker, pre-selected for torture and goaded beyond endurance. The resulting violence was not just a possibility, but a certainty. The danger was not to the speaker, but from him. What is proclaimed here as freedom of speech is really freedom to torture. Fortunately, only one person was injured. The poor woman who was struck down by him as surely as though his fist had knocked her to the ground. Your Honors, this man went too far. And I urge this court to affirm the conviction. Thank you.
Thank you, gentlemen. Cases like this are difficult to decide because there is a great deal to be said on both sides. We agree with Mr. Newlin's attorney that our Constitution does not permit us to uphold Mr. Newlin's conviction simply because of our deep dislike for what he said. But we also agree with the attorney for the state that the state has a legitimate interest in preventing violence and the deliberate use of words to inflict injury. But at what point do we balance the vital concept of freedom of expression against the state's need to preserve the peace? And haven't tyrannical regimes always vindicated their suppression of freedom by using the peace and the security of the state as an excuse?
One of the most difficult problems facing a free society is determining when, if ever, an individual's freedom of speech should give way to the community's need for law and order. Should this man's conviction for disturbing the peace be upheld, or should he be released?
We will take the case under advisement, and you will be informed of our decision shortly. Thank you.
How would you decide this case?